Operation Mantus is an investigation that started with a complaint about the way police arrested and detained a 14-year-old Aboriginal boy in northern New South Wales in September 2022. Police had intensified their proactive policing response to a spate of theft and looting in the community after the catastrophic floods of that year. The young person's lawyer made a number of complaints to us about his treatment, the way he was arrested and handcuffed, the absence of body-worn video of the incident, and the way police questioned him after his lawyer from the Aboriginal Legal Service had informed the custody manager that he did not wish to be interviewed. The Director of Public Prosecutions had also complained to the Commission about similar cases where the police improperly interviewed vulnerable people. Subject to some narrow statutory exceptions, all people in Australia have a right to silence. That is, to choose not to answer questions put to them by the police about an alleged offence. This right is based on the principle that the prosecution bears the burden of proof in a criminal matter. This important principle is protected in both legislation and case law. It is essential to the fairness of criminal proceedings. The law creates extra protections for vulnerable people in custody. This includes children, people with mental health or cognitive impairments, and Aboriginal and Torres Strait Islander people. The extra protections require police to help a vulnerable person get access to legal advice before police questioning. Legal Aid and the Aboriginal Legal Service usually give this advice on the phone. If the lawyer is giving phone advice, they rely on police to act properly when their client exercises their right to silence. It is the responsibility of the police force to give clear and easily accessible guidance to officers about how to properly interview vulnerable people in custody and about protecting a person's right to silence. Our investigation traced a history of court cases in which police had obtained admissions from vulnerable people in circumstances where they had refused to be interviewed. Where this had happened, the evidence may not be admissible and the court will not consider it. If the court can't consider the evidence, it can compromise the entire prosecution case. Almost 20 years ago, the police force did have protocols in place to instruct police how to properly deal with a vulnerable person who chooses to exercise their right to silence. It is deeply disappointing that these protocols have fallen into disuse. The improper interviewing practices we saw in Operation Mantus were not isolated to that police station in northern New South Wales. This is a systemic problem. It has occurred in police stations throughout the state over a number of years. We have recommended the police force immediately issue clear instructions to custody managers about these matters. We have also made other recommendations to strengthen police training and the way they create instructions after the courts have pointed out problems with their practices. We will follow up with police to ensure these recommendations are implemented promptly and effectively.